Okay, our first case today is State of Florida versus Michael John Phillips, number 2023-0073. Go ahead.
Good morning, Your Honors, and may it please the Court. Robert Shank for the State of Florida. By voluntarily reopening the package of sanctions that the trial court imposed on him, Mr. Phillips defeated his own expectations of finality in that package. That undermines no promise under the Double Jeopardy Clause. That clause is neutral as to sentencing. It leaves to the legislature to determine when a defendant has an expectation of finality. And all of the federal courts agree. In a package jurisdiction, a defendant has no expectation.
Can we get past the, it seems to me like this package business is a little bit of a bumper sticker, because it is possible for example, sentences to be run concurrently or consecutively in a regime, a sentencing regime, and yet have it be different in some other way from the federal sentencing regime. And I think the parties in this case, the state as well as Mr. Phillips, have briefed this as if it's a binary choice. Either it's a package model or it's not. Where it seems to me the criminal punishment code reflects there are some respects in which the enterprise of sentencing is multi-count assessment. Obviously, it's baked into the score sheet that we look at a total offense level, but yet we have a separate sentence as to each count of conviction. There are both separate and package elements to it, and it doesn't seem to resolve the real question in this case, which is what is the defendant's legitimate, constitutionally protected degree of finality in a sentence that not only has he not appealed, but that the state has not appealed, and that is illegal or incorrect. And I wonder if instead of making this an argument about package, no package, you might address what constitutional interest a defendant has in a sentence that the state doesn't appeal, even though, in retrospect, is not the sentence that is demanded. It's not the LPS that is generated by operation of the score sheet, and yet the state is silent when it's entered. What constitutional interest of finality does the defendant have in a case like this?
So, in terms of constitutional interests, generally what we see are two constitutional interests at play when we talk about sentencing and one of the counts gets vacated and remanded. So I do think that the federal court's approach, well, first, the two interests I would say are the Double Jeopardy Clause and the Due Process Clause. Now,
there's nothing textual in the Double Jeopardy Clause that says that I have this this interest is protected. But of course, we are operating where, okay, so that our Double Jeopardy Clause and the federal Constitution, the U.S. Constitution's Double Jeopardy Clause, are textually identical, and both this court has acknowledged the sort of coextensive nature of the protection, yes. And therefore we're sort of operating under U.S. Supreme Court law, which has identified three components of the Correct. Double Jeopardy protection. Okay. Yes. Would you concede that the text of the Constitution, frustratingly, doesn't answer the question here?
No, but certainly, I think after DeFrancesco, the Supreme Court has interpreted at least the sentencing portion of the Double Jeopardy Clause. I mean, a lot of constitutional rights are somewhat opaque and have to be elaborated on by the courts through looking at the text, but also history and tradition. And at DeFrancesco, the Supreme Court said that it wasn't a bar to an increase on remand after it had been imposed.
But DeFrancesco just gets you to the idea that under a given sentencing regime, there would be nothing constitutionally that would prohibit the sentences on the unchallenged counts from changing. It seems like the way the federal courts look at this is that there's kind of a two-step process that they go through. The first is just kind of jurisdictional almost for the trial court when the case comes back. Like, what are they, putting aside the Constitution, the due process clause, like what are they allowed to do? And then the question is, okay, assuming they have authority to look at the other non-challenged sentences, then did they do something that would then violate the double jeopardy clause? So in our situation, it seems like the threshold question seems like it would have to be, given that those other counts weren't challenged, or in this case, the one other count wasn't challenged, just as a matter of sort of almost like, treat this not as a constitutional case really, but as a statutory case or an inherent judicial power case. Like what, should we be looking for something in the criminal punishment code that says judges on remand can relook at whatever? Do you agree that if the CPC said that, hey, defendants, prospectively, if you appeal any part of your sentence, just be prepared because when it comes back on remand, if you prevail, all bets are off. Like, you agree that would make this an easy case, right?
Yes,
okay.
I do.
And so should we be looking for some kind of affirmative grant of authority to the trial courts to engage in this kind of re-looking at the other stuff? Because if there's no authority for them to do it, at that stage, then the double jeopardy issue goes away. Do you agree with that?
So I do agree if there were an affirmative grant that would go away, but I don't think we need something that says explicitly, Florida adopts the packaging approach. I think that... Well,
it wouldn't say that.
Right.
I mean, right. It would say it would be some sort of an affirmative, because part of the problem here is that this whole reasonable expectation of finality is a function, one way to look at it is kind of in the abstract. If the sentences are kind of almost, as you guys say in your briefing, as a matter of common sense, even if they're not sort of interlocked in a way of a score sheet thing or anything like that. Like, obviously you've got these 3 counts of conviction. The judge is trying to come up with something that's fair and that reflects the offense and the offender and yada yada. Mm-hmm. So if you pull one thread out, you've got to redo the whole thing. That's kind of as a matter of common sense. Another way of looking at it would be that, based on the underlying statutory scheme, I just sort of know going into the game what the rules are. The problem with this is that we have no explicit textual indication of what the rules are. And if I'm talking about reasonable expectations of finality in terms of what a particular defendant in Florida is looking at, maybe as a matter of theory, there's no reasonable expectation, but it seems like we've got decades of just kind of practice in Florida that kind of tells these people, I can pick and choose what I'm going to challenge and it's not going to change. And so I feel like part of what our challenge is what baseline has, putting aside the constitutional question, mm-hmm. what baseline has Florida law kind of established and who can change the baseline? One way to change the baseline would be for the legislature to just change the CPC and make it explicit. Another way would be for us to just say, hey, guess what? After however many decades, that reasonable expectation that you thought you had, it was never there because it's all interconnected and you should have known that all along as a matter of common sense, which sounds like that's kind of what you're asking us to do.
I don't think I'm asking the court to, engage in any judicial policy making about what is the wisest choice that Florida should adopt. But I want to back up a second and say I agree. This case is not particularly a constitutional case. It's a statutory case. The question here is whether Florida adopts the package model. And if it does, there's no double jeopardy interest. That's what the federal courts in DeFrancesco, I think, stand for.
They also, the federal courts, it seems like they look at the package. The package thing is sort of a court label, and sometimes in the cases it's like literally it'll be 2 counts of conviction where if you get sentenced for having a gun on one count, you can't do an enhancement for the other, but then the gun thing goes away and so all of a sudden it's legal to do the gun enhancement, and so they're intertwined in that way. But there's also kind of a prior, they look at the law and say, here's some grant of authority in 2250 whatever that says district courts can do yada, yada, yada. Like, is there anything in Florida that's comparable that kind of says when a sentencing court gets a case back on remand, they can look at the whole thing?
Well, as I understand it, I don't think federal law is particularly explicit as well.
3553A is pretty explicit, it sets out what a district court is supposed to do at sentencing, and it is a statutory grant in the way that Chief Justice Muniz just articulated. I think your best answer to his question has to be someplace in 775, right? The rules of construction that sort of talk about what a court is supposed to do. But I'm sorry, federal statute does govern sentencing.
Well, it does govern sentencing, but of course, I don't think, at least not to my mind, they have an explicit grant about the extent of authority on remand. I may be wrong about that, but
it's not about remand in the federal. There is no limitation on what a district court judge can consider at sentencing, and there's an affirmative grant of statutory authority to the district court at sentencing to do a holistic analysis. And that's why the analogy is a little shot, because there is a whole statutory structure that governs federal sentencing that is absent at the state level, I think.
Well, I agree that there is a statutory enumeration 3553A about what factors a district court is supposed to consider in federal court. I think that Florida law also embodies somewhat similar principles. In my mind, what 3553A does is it embodies a very common sense understanding of how judges naturally sentence, and I don't see anything in the CPC that prevents the judge from considering virtually everything and exercising the discretion that the CPC gives him. So I want to point to three textual indications that we think indicate that that's so, that a judge is looking at an intertwined series of offenses in a multi-count case. I mean, we talked about the concurrent consecutive distinction. I think it is important because a judge can only exercise that choice by thinking about the total sentence that the defendant is going to serve at the end of the day. I also think the most key part about the CPC is the LPS is the lowest permissible sentence. That calculation is intertwined. The judge calculates that by looking at all the accounts of conviction, all of the harms from all of the counts of conviction, as well as the offender's prior history and several characteristics about the defendant, like his legal status. And then they take that intertwined score and it applies to every single count. And if that count, or if that intertwined score exceeds the statutory maximum, that intertwined count governs over the statutory maximum. That is
on a count-by-count basis, as we said in Gabriel.
Yes, that is true. That is true.
It seems like that's all fine, though, when you're talking about the initial sentencing. But really, the question, though, is both in terms of what the judge has to decide and then how the judge might exercise the discretion. But really, the question here is, once you've undone part of it on appeal and you come back, what can the judge do? And that's, sort of the logic at the front step. The reasonable expectation of finality question just doesn't really go to the logic of the first step. It goes to the structure. I mean, so do you, if you accept the premise that this has been for better or worse, and I agree that if we could go back to step one, I'm not sure if what we're doing makes sense. But if this is just the way we do it in Florida and it's been going on for a long time, and I'm not sure that how persuasive the change to the CPC argument really is. Some of this feels to me like, if this is going to change, why can't the legislature just change it? Why should we kind of reinvent the wheel decades into the game?
Sure. So I want to address all parts of your question. So obviously the legislature could do so, but the question here is whether the legislature has already done so. And I take your question in large part to be drawing on this court's opinion in Fazemeyer from 1984, where the court rejected the package model as it existed, as the sentencing statutes existed in 1981. Although the case was 1984, it was applying the 1981 sentencing regime in Florida. So I don't think that case binds you for two reasons. So first, Fazemeyer was before the sentencing revolution in Florida with statutory law. So in Fazemeyer, the way that sentencing worked is the judge would, have a bunch of counts before him, and the sentences on all of them were totally separate. They would give it an offense classification, and they would go into 775, and it would say, well, if it's a level A felony or a class 1 felony, you get 5 to 25, or 5 to 10, or I believe it's just a maximum. And so all the sentences stood really separately. And in light of that, I think Fazenmeyer looked at the ban on general sentences and said that that type of ban indicated that Florida had rejected the package model, that sentences weren't intertwined. Now, we don't think that the ban on general sentences was ever that probative about the package model, right? There's a lot of reasons why a legislature may reject general sentences, yet still have the package model. If a legislature creates rules about individual sentences, it needs some way to police them. And also, the ban on general sentences is a good deliberative tool. What it forces judges to do is think about each piece in the puzzle in addition to the holistic analysis about how he's going to sentence them at the end of the day. So in light of that, then, and only after Fazenmeyer, admittedly in 1983, there were some sentencing guidelines, but it wasn't applying that. And we had several iterations of new statutory systems that were reticulated and completely upended the way that sentencing was done in Florida. And so I want to point you to a case from the 11th Circuit that I think is particularly instructive. It's United States v. Fowler. And in Fowler, what the 11th Circuit was looking at was a packaging model case that it had decided before the guidelines were put into effect. And what the court said there was that that prior opinion didn't bind it. Not that it was distinguishing it or overturning it. The panel couldn't overturn its prior panel precedent. It said that it couldn't bind it. It did not and could not bind it because the guidelines.
Can you address the premise, though? So it seems like we've had discussion about what are we looking towards to determine from a constitutional perspective whether this sort of action is prohibited. And so you've been presented with looking at the CPC and seeing if there's an affirmative grant of authority. I think the alternative, and it might be splicing words, but I think it's somewhat significant, is looking at the CPC and seeing whether this sort of action on resentencing is prohibited by the CPC. And then the I guess third alternative is looking at considering case law, considering practice, and considering the statutory text, whether there's just a kind of a culture in Florida that only the sentence that's challenged would be affected on resentencing. And so from those three options, from a constitutional perspective, what are we trying to figure out what the answer is? Is it that the CPC prohibits, it affirmatively grants, or are we looking at it from this holistic practice, case law, CPC sort of model? So
I think that in my view, the primary consideration should be the text of Florida's sentencing system. And obviously in a case where it's not affirmatively granted, I don't think it necessarily prohibits it. Now, I do think that there is a relevant strain of case law from the federal cases, right? Because in Florida, many of the courts believed they were bound by this court's decision in Fazenmeyer. We think that it's clearly erroneous, but they still felt bound, so they had to apply it, even if they thought it was wrong. But in the wake of Fazenmeyer, the federal courts started adopting the package model, court after court after court.
And from a text, go ahead.
Is your answer to her question, though, that your kind of inferences from the structure of the text kind of trump, in terms of deciding what the reasonable expectation is, that the reasonable expectation that I would get from making inferences about the structure of the CPC trumps the culture sort of path 3 that she was talking about?
Yes, I think one, because obviously the CPC revolutionized, or the multiple guideline systems, and then the CPC revolutionized Florida's sentencing system. And I think taking that in light of how federal courts have adapted to the sentencing guideline system, I think a person looking at the legal landscape, seeing that every single federal court is unanimous on this point after they adopted the guidelines, and then looking at Florida's system, I think that they could infer both from the text and how things had developed in the federal system.
So but I mean, it seems like the text, you'd have to be pretty strongly persuaded that the text had reached that there was kind of a certain kind of level of compellingness to the inferences that you would draw to overcome. I mean, you're not really disputing this kind of point about the culture and practice in Florida, and that's been going on for a long time.
I think that the practice can be helpful, but I think there's a lot of reasons why.
It's just kind of strange to tell someone, because this is weird, this reasonable expectation. It's just kind of strange to say that the practices and the logic in the federal case law would trump like what's been going on in Florida for decades.
Right. Your whole argument does presuppose that there is a difference between what happens in the federal world and what happens in Florida, right? So we shouldn't just walk past that. It's a matter of fact that this expectation exists. And what I hear the chief asking is, okay, so is that located in something that we should upset when it's the legislature's role to set such a policy or not? That's, I think, what we're getting at.
Right, and I think that inference can be drawn from the text of the CPC. I mean, that is our principal argument. But to the extent that practice is relevant, Your Honor, I would say that that practice has to be taken in light of the full range of legal circumstances that the.
Do we know the practice though? I mean, do we know that that currently on resentencing, that judges are not assuming that they can resentence on all counts where the LPS was off, absent like a mandate? I can see, in the appellate system,
right.
If it's coming back on a mandate, it says resentence on count 1, which I think you could see, even if we decided this case in your favor, that would still be within the appellate court's discretion to narrow a mandate. But how are you? I guess maybe let me ask it this way: are you conceding that it is the practice in the state of Florida that everybody on resentencing, absent a narrow mandate, is resentencing only on the count that was challenged versus the entire all counts at issue?
Answer. So, Justice Sasso, I would say that we don't concede that is necessarily practice. Obviously, this case provides an example. I do know that there are cases where the DCAs apply Fazenmeyer, but I don't know that it's a universal practice. We haven't looked into whether this is a universal practice.
We just don't have that information.
Yeah, we don't have that information before you today. I
have kind of some practical questions about if we adopt what you've proposed today, how this would look. The certified question says, can they resentence on everything to comply with the law or to effectuate the intent of the sentencing court? Do you think that under your model they could, for any reason, reopen all counts and sentence, just at the discretion of the judge? Can they make it significantly worse? That there was an invalid sentence to begin with, and as we have in here, and it's not really about the intent.
Certainly, we don't think a trial judge's subjective intent is what the best way to run the railroad here.
Okay. So what limitations would be on the resentencing judge in how the resentencing scope?
Yeah, so I think that is, if the court does adopt that approach, it's going to have to address those questions when they come up. But my inclination, based on what...
Well, if we adopt that approach, we're about to open up everybody for resentencing on every count. We have to give some level of guidance as to what that entails. So what would be the state's position on that?
Well, I'm not trying to dodge the question. My inclination is that it might be best to give the trial judges some level of discretion to decide whether they're going to reconsider just the count or conviction, the sentence for a conviction that was vacated and perhaps retried, or to open up all the counts.
Okay, so if they open up all the counts, it's a new resentencing judge, can they give a lower sentence?
That's perfectly fine.
So if the state's position is new judge, new resentencing, they can give, as long as it's within the code, it can be any type of sentence, completely open.
Yeah, the CPC tells us to punish, I think this is another piece of textual evidence I think is relevant, to punish the offender. Okay. Right?
And at a new resentencing hearing, it's de novo, correct? I mean, so if in the state's model, if it is reopened, then the defendant is entitled to a completely new sentencing hearing and to present any new evidence, anything else. So we're saying for all of these cases that go back, the trial court now will conduct a completely new resentencing hearing as if the first one never happened.
Right, like what happened here, yes.
Okay, and my final question is your position the same if the state appeals the sentence?
In other words, if we appeal the sentence, the trial judge could reopen all of the
Yes,
yes,
there's no finality, even if the defendant chooses not to appeal.
That's a harder question, Your Honor.
Because if we adopt that it's a package model, then it shouldn't seem to make any difference.
I don't think that I think that's a tough question, Your Honor. My inclination, I don't want to give a binding position for something I haven't fully considered, but my inclination is it may be different, again, because the double jeopardy clause looks to the legitimate expectations of finality of the defendant, and typically in the package model cases in the federal court, they say, well, when a defendant voluntarily reopens his package. I'm not sure what would happen in that instance, to be honest. It may be different.
Thank you.
Okay, you can have 3 minutes.
Thank you, Your Honor.
And if you need a little bit of extra time,
Thank you, Your Honor. May it please the court. My name is Nick Shanine, and of the Shanine Law Firm, and together with Bill Pinal of the Pinal Firm, who by appointment of this court represent the respondent, Michael John Phillips, would address the issues before the court. Mr. Pinal will address the constitutional and statutory criminal law framework issues that this court has addressed. My only role here in a limited time will be to provide this court any insight regarding the appellate practice threshold question, which Justice Curiel referenced with regard to the fact that the state did not appeal the second count.
So on that issue, and I'm assuming you're talking about the waiver argument.
That's correct, Your Honor.
It was a separate proceeding that the state now kind of has an argument that they could not have made when the original sentence was imposed. And so how is that a waiver if the idea is that you have to raise the argument at the earliest opportunity? I think the argument is that on resentencing, all counts should be resentenced. Why are we looking at this from a you didn't appeal that sentence?
And the answer, Your Honor, is that the issue that they want to raise would certainly be appropriate. The problem is that you can't change the facts. The case law of this court, the Dade County School Board versus WQBA case that talks about the tipsy coachman principle, says that you are allowed to raise any issue supported by the record, but you can't undo the record itself, where if you fail to appeal or object to this second count, even if later analysis says, oh, that turns out that was improper, that means that is now frozen. And that's this court's case law in Gartrell.
Does this argument kind of depend, though, on it not being a package sort of sentence model?
There is, while we would disagree that the two sentences are intertwined, we would agree that these two issues are intertwined, and that's why I'm about to pass the baton to Mr. Pinal to answer that part of the question.
So in other words, if for some reason the majority of the court determines it's a package model, the waiver issue doesn't really come up because it would have been reopened. It would have been an argument that could be made in a de novo sentencing context anyway.
And of course, as Chief Justice Muniz has noted, it's important that the rules of the game should have been known to the parties as they did that. When he appealed only the first count, or questioned only the first count, and the second count was not appealed by him nor by the state, that's why those facts matter. And that's why we believe the threshold matter of waiver does exist if the court elects to use it. However, these other
on that same argument, and I don't know if this is necessarily relevant, but the defendant also did not appeal the sentence when it was opposed and then came back on a 3800B motion.
And that's the case law, again, under Gartrell says that's the way that the process must work. The defendant is allowed to do that. The state, if it wanted to challenge, does not have that remedy. It must appeal. And it chose not to. And that which was done is done. And that is the point of the threshold waiver issue. With that, I would like to ask the court to hear the argument of Mr. Pinal regarding each of the important double jeopardy and statutory issues.
May it please the court. It's our position that this is a legislative issue, and this court has repeatedly examined the plain language of the sentencing statute, starting with Fastenmeyer in 1984, followed by Moore, and most recently in Gabriel about 4 years ago. And each time, this court has concluded that the plain language of the statutes indicate that sentences for each conviction are not interrelated.
Well, and this is one of those, I want to avoid the bumper sticker. Of course, they're interrelated in the sense that the score sheet uses the total offense, computation. The state's right about that. But you reference Gabriel, and Gabriel is significant, but it's obvious that it doesn't answer today's question, or else courts would just be citing Gabriel. So what I'd like to sort of drill down with you about is why is it that Gabriel doesn't answer our question today? And I think it has something to do with the fact that we're here on resentencing. It is in some respects a de novo proceeding, and the question is what kind of finality interest your client, the constitutional question, we'll come to the statutory question in a minute. The constitutional question is what kind of finality interest does your client have in a sentence that, I mean, you're kind of like whistling past the graveyard. You know the sentence was lower than the lowest permissible sentence. You don't appeal it. But does he have a finality interest in that sentence, even though it should not have been given? That's, I guess, my first question.
And the answer is, I think you go look at D. Francesco from the United Supreme Court, and they say that the defendant doesn't have an expectation of finality until the state's appeal, or the government's appeal in that case, is concluded, or the time to appeal has concluded. And in this case, the state chose not to appeal. So once they chose not to appeal, he had a reasonable expectation of finality.
Even if the sentence is illegal?
Illegal might be different. This is not an illegal sentence. This is an invalid sentence, because there could have been a downward departure if there was a basis. So the sentence, it would be different if there was it could be different if there was a minimum mandatory that was required to be imposed, but this was within the court's discretion to impose, and because it's just invalid, the defendant had a reasonable expectation of finality once the state chose not to appeal. That in Florida's system, there's no rule or statute that gives the state the ability to challenge a statute.
I think
after
Francesco, though, it didn't focus it on the appeal. It's trying to determine whether an appeal is similar to an implied acquittal. It's trying to work in the issue presented, which was an appeal in that case, into the overall double jeopardy framework, which is this structure an implied acquittal for the purposes of double jeopardy. And so I don't think we need to get caught up in, is it an appeal or not an appeal? We're trying to see whether, under the CPC, whether somebody who challenges something on the 3800B ends up with resentencing, whether that's an implied acquittal under D. Francesco, rather than skipping that step and going to the...
But I think, as the other justices have noted, I don't think there's any indication in the CPC that indicates that the state has the ability to challenge a sentence other than by direct appeal. And
yeah, so then we need to look to the CPC to see whether the defendant would expect, if he challenged a sentence, whether the other sentences would be opened up on resentencing. So I agree with you that we should look at this from the defendant's perspective rather than whether or not the state appealed. I'm just not sure how whether or not the state appealed is relevant to that question of the defendant's expectations.
Well, I think this court and I think the U.S. Supreme Court in D. Francesco, I mean, there was dispute between the majority and the dissent. The dissent thought that the sentence could never be increased based on a government appeal. What the majority said is it's okay, it's not a double jeopardy violation because there's a finite period for the government to challenge it, and then after that there's a reasonable expectation of finality. And because from the defendant's perspective, he knows, because he's charged with knowledge of the law, that the only way the state can challenge a sentence is on direct appeal.
Yeah, so then it does kind of come down to the package issue. I mean, on if it's about the only way that this sentence can be challenged is by the state. Right?
And when you compare the Florida statute 775-021 subsection 4 and 921, there's repeated indications that each sentence, each count needs to be sentenced independently and have a discrete sentence. When you read 3553, US 3553, it talks about a singular sentence.
Can I ask you about some of the other similarities? So one of the questions earlier was about the similarity between Florida and federal law on the specificity regarding resentencing. And if I understand the federal structure correctly, the sentencing guidelines don't explicitly state directions for a court on resentencing, right? In other words, it doesn't explicitly say on resentencing, you can resentence the entire package, et cetera. The federal courts have been interpreting essentially what our CPC would. There's no direct.
I think the only
no direct authority for the federal courts.
I don't think there's a direct authority on resentencing, but when you read the general statute on sentencing, 18 USC 3553, it talks about a sentence as a singular package, as opposed to 775-0214.
So in other words, our enterprise is the same. We're looking at not for direct authority on resentencing. We're looking at the CPC, just the sentencing structure overall, to determine whether this would be. And then what would your answer to that be? Either granted, the authority explicitly granted, or prohibited by the code from a statutory standpoint?
Well, I think by the legislator, by stating that there has to be discrete sentences, is saying that there isn't a package model. So I think that's the only textual context we get. We certainly don't have an indication that the trial judge is prohibited from doing this, or the trial judge is prohibited from doing it. But we do have an indication, an explicit indication, that's been there since Fassenmeyer, that there's distinct sentences for each count. So I think that language, and if this idea that the federal system is doing it differently, Fassenmeyer decided in 1984, if the legislator wanted to make it clear that this was a packaged model, they would have done it.
How do you define package model? I think your friend on the other side used the word intertwined, which I find a helpful framework. There's no federal test, on the case law for determining what's a package model and what's not in the states. What test would you use to determine whether something is a package model?
I think you look at the statutory language where they say impose one sentence as opposed to distinct sentences for each count. So the package model would be, if the Florida statute tracked 3553 more closely, then we'd be in a different position. But anybody that's been in federal court and done a federal case knows that federal sentencing this is apples and oranges. This is way different. And that the statutory language is in complete conflict. One talks about sentencing in the singular, and the other explicitly says separate and independent sentences.
So if we were going to write an opinion favorable to you, one thing, if the majority is persuaded on this statutory thing, we would talk about that. But then this other aspect of sort of the practice in Florida.
Sure.
How concrete, what can you give us that's, more than just this kind of, general sense or feeling or perception? I mean, what would one point to establish the notion that we're sort of disrupting kind of a settled status quo by sort of declaring now that there was never a reasonable expectation?
You would look at Fassenmeyer, you would look at this court's decision in Moore, and you would look at this court's decision in Gabriel. And in each and every one of those cases, this court indicated that there was separate and distinct sentences for.
But see, to me, that doesn't really get you. I don't know that gets you.
I think it does,
all the way that you want to go.
I think it does, because I think the legislator then has the ability to react to those decisions and say, that's not what we want. So, and Moore explicitly tells everyone, under the CPC, the offenses are not interrelated. One score sheet, but multiple sentencing ranges. So
I think
that gave the legislator go ahead.
Well, I think just to follow up on that and what came up before, is this, in the DCA world and in trial court world, is this something that is happening? Are they resentencing all the time on all the counts? Are all the courts feeling that they are bound to only resentence on the count that was on appeal? I mean, what is happening in the practical sense?
I mean, personally, I've had both. But I've certainly 2 years ago lost a case in the 5th DCA where they said, where I got a de novo sentencing, and the 5th DCA said, no, that wasn't appropriate because your client only challenged these 2 counts, so you can only get resentencing on those 2 counts. So that's the current state of the
Also
law.
from a practice.
I mean, don't we really have to look at what the cases show, right? And if am I correct in understanding that the state really doesn't have any case law that directly supports what they want to do, whereas you do have case law that directly supports. Is that correct? And not
Yes, I believe Fassenmeyer, Moore, and Gabrielle fully support our argument. And if the legislator wanted to change it, they've had.
Well, is there anything in the case law that directly supports what the state is asking us?
Not that I'm aware of, Your Honor.
And I'm talking about the state case law. Obviously, they can point to the federal stuff, but
Not that I'm aware of, Your Honor.
Can I also sort of explore with you the extent to which the textual clues that the state was identifying? I'll start with 775-021. Support or don't support your position or the state's position. So 775-0214A says that whoever in the course of one criminal transaction or episode, so it does identify we'll call it a package for now, one criminal transaction or episode, commits an act or acts which constitute one or more separate criminal offenses, upon conviction and adjudication of guilt shall be sentenced separately for each criminal offense, and the sentencing judge may order the sentences to be served concurrently or consecutively, period. Okay. What work does the word separately do in that sentence? It appears twice. There's separate and separately. Given the fact that the sentences may be served concurrently or consecutively, what work does the word separately there do? I mean, if I'm able to give a separate sentence for each count of conviction and yet modulate the total length of someone's time in state prison, what do you think the legislative bargain is, or that is reflected by the use of the word separately there? What work does it do in the statute?
It makes it clear to the judge that each crime must be sentenced separately or distinctly. It doesn't matter that it's in one episode. I mean, it used to be that if there was an argument that if there were multiple victims in a DUI manslaughter, you could only get charged with one offense. What this language has been interpreted to say is, you know, if one course of conduct results in multiple crimes, you have to give a separate sentence for each.
Okay, so that, when I look to Rule 3.700, the definition of sentence, the term sentence means the pronouncement by the court of the penalty imposed on a defendant or the offense of which the defendant has been adjudicated guilty. So again, it speaks to a singular offense.
Right.
Okay. Given that, the next question becomes, what about on resentencing, right? So is there a textual basis for your position, or is it just essentially a due process once we get to the resentencing part? Because I'm with you so far.
The only textual base, there's no, I'm not aware of any direction or statutory language that talks about resentencing specifically. All we know is that the statutes regarding sentencing talk about independent and distinct sentences. So I think that's the only statutory text that addresses this.
But the federal sentences are separate, and I mean, we're sort of chasing ourselves around on what's a package or whatever. But I mean, if all that the word separately does is just to say that you're going to enter a sentence for count 1, count 2, count 3, whatever, that's the same thing in the federal system, right?
No, but this court has interpreted that to mean that the lowest permissible sentence is for each offense.
Right. And that's fine. That's extremely relevant at the moment of sentencing when you're trying to decide what to do. But all this stuff about what happens on remand and when I challenge one, do I put all the others in jeopardy? That's just seems to me like a completely separate question that's not really answered. I don't see it as a textual thing. I mean, that's why, to me, it seems like maybe I don't know what cases you look at or the practice or whatever, it seems like what they're asking to do is to sort of change sort of the norm.
Well, we know the practice based on this court's decisions, and the law has been that if the defendant doesn't challenge one count, if he challenges count one and not count two, then count two is not subject to being changed.
When we talk about the practice at sentencing, though, from an intertwined standpoint,
Sure.
Would you agree that the package of trial courts, when they're imposing the original sentence, whether they're going to run something consecutively or concurrently, the range within the allowed sentence that they're going to pick, do most courts do that with an eye towards the overall sentence?
I don't know what most courts do. I know that Gabriel tells them now that they need to do it independently. So the
CPC is certainly structured, though, to allow a court to do that, right? I mean, the court has discretion to kind of say, all right, I think the crime was this bad. I'm kind of looking at 30 years overall. I'll run these three, consecutively as a result.
certainly gives the judges discretion to make that decision. But again, I think the most important part is this court has consistently interpreted the language to say that there's separate and distinct sentences all the way back from Fassenmeyer through Gabriel. If the legislator
and do you want to address the state has a section in their brief, inconsistencies with other case law, and cites Blackshear, a recent third DCA case where the court said that the entire package, so to speak, could be resentenced.
In all the cases that the state cited in support of that argument, it appeared to me on their appeal they challenged both sentences. So there wasn't any question about whether one or the other could be handled on resentencing. It looked like either the defendant or the state had challenged both sentences. So the defendant didn't have a expectation of finality because he was challenging, or he knew the state was challenging both. I don't think the state has cited a case where, similar to here, where only one was challenged. For the reasons we've argued, I'd ask that you approve the decision of the Second District.
Okay.
Thank you.
Thank you.
Have a few points.
Would you respond to that last point? Is he correct in what he said about your cases?
I am the specific posture of Blackshear is escaping me, but I do know that
I'm sorry, I didn't understand what you said.
Sorry, the specific posture of Blackshear is escaping me at this point, Your Honor, but I do know that in Fassenmeyer, where the defendant challenged the sentences, this court said about the holding about the package model they brought up in count 3. In count 2, this court said the court would have been free to change on remand about the second count from concurrent to consecutive as long as it stayed within the guidelines of Pierce. So that, I think, says that the court can change the overall sentence on remand. It can change it from concurrent to consecutive, Your Honor. And so
that sounds dicta-ish.
I mean, that at least based on what the text of the Blackshear and the DCA case that we cited, I know that they thought that language implied that they could do that on remand. I don't want to rely on dicta-ish, but I just want to bring up two limits, Justice Grosshand, to what you said. First, when it comes to the discretion that the trial court might have to reopen, I think it's important to note that I expect, and you could instruct courts to consider how an appeal might affect those other sentences before exercising their discretion to reopen the entire sentencing proceeding. And of course, vindictiveness is always going to be a protection, a limit on a district court's or a trial court's ability. A trial court's ability to re-sentence in certain ways. And then when it comes, Justice Sasso, to your point about the holistic nature of sentencing under the CPC, my understanding is that nothing prohibits a judge from acting holistically, thinking about the sentence at the end of the day. And in fact, I think that it is the command of the CPC, because in its principles, the CPC says the primary purpose of sentencing is to punish the offender, not just consider the severity of the offense, which it has in another portion that they are also supposed to consider. To me, I read that as saying the job of the trial court is to sentence not just the crime, not just fit the punishment to the crime, but also the criminal. And as far as
what do you say though to someone like me who is skeptical from the out, who thinks that maybe we got off on the wrong foot, even under pre-CPC, and that it was misguided not to have sort of viewed it as a package for the very reason that you say, that it's just common sense, but that there's been this long kind of understanding in our state that that's what we do, and that creates the reasonable expectation. It just, my problem is that we're sort of having to go, given the nature of the test, it'd be different if we're trying to try to find the quote unquote objective meaning of some written thing. But now it's like we've sort of set the rules of the game, arguably, through the practice that we've had in this state for a long time. And the question becomes like, how do you change the reasonable expectation? It just seems like the better approach would be for the legislature to directly address that. And then they could also kind of fine tune. Maybe they want them reopened in some cases and not. Maybe only when one of the others is, unlawful or whatever. I mean, you know what I'm saying? We're going to kind of having to be making it up on the fly. So how do you respond to that?
I have two responses, Your Honor. So first, let me survey the responses. So the first is I would say that I don't think that case is binding on you because of the changes in the statutory nature of the system. And I think that has to impact. The changes in the text have to impact, or at least when we identify material changes, have to impact the expectations.
Which material change?
So I think the creation of the LPS, Your Honor. I think the directive at the beginning of the CPC that tells them to focus specifically on punishing the offender. And I do think that the concurrent consecutive distinction, while it existed before, if you don't believe that Fazemeyer...
But isn't it true that none of our courts have recognized what you're saying? I mean, you're saying it had to change it, but it doesn't seem to have changed it, has it? I mean, but the Chief's point here is that all this is intertwined because you've got this expectation that has to be based on what courts are saying and the way the courts are understanding these things, not based on what some uber textualists might come up with. So what am I missing there? I mean, because I don't see how you get around that.
Well, Your Honor, I do think that if the legislature completely overhauls a statutory system, I mean, we're always going to have to interpret that system for the first time. And I understand...
But again, this didn't happen yesterday. Okay, you're talking about changes that went on when I still had hair on my head. I mean, this is a long time ago. I just... and then the courts have been dealing with it, but not in a way that appears to me to support your position. And I don't think that you're not really pointing to anything that Florida courts have said that support what you're saying about how this change in what a sentence defendant could legitimately expect about the finality of a sentence would be.
Well, Your Honor, I mean, again, I think that it takes time for these issues to percolate. I mean, the case that I identified from the 11th Circuit, Fowler, where I talked about the pre-guideline sentence, I mean, that was pre-guidelines to 2014 before that issue finally came back up to the 11th Circuit. So I think that the job now is to take a fresh look at the CPC and approach it as a text and ask what it means.
Okay,
and then,
you can have 15 seconds before I finish up.
Thank you, Your Honor. I would just say that the other opportunity, you may consider that this defendant, Mr. Phillips, may have an expectation of finality, but to address the CPC going forward, that may be another possibility. So thank you, Your Honor.
Thank you. The court's going to be in recess for 10 minutes. Thank you.
All rise.